Call this meeting back to order. 1:30 p.m. Corey Swanson, County Attorney, BCSO Collective Bargaining Agreement Renewal, discussion and decision.
Do you want to come up, Sheriff?
Pretty comfortable.
Since you're a star player in this drama. So we, as a committee, met and went through the negotiations with the Teamsters.
Thank you.
And I just brought one copy of the actual old agreement, but anyone that wants to look at it, it's right here. And what these are the amendments to the existing agreement. I'll just walk through these. The union has voted to accept these, subject to commission's acceptance. So, first one, and I think in this, so Commissioner Robert was in on it, and Sheriff was in on it, so any of these, if you want to talk about it more than me, I'm fine with that. Otherwise, I'll just kind of highlight what we're looking at here. Paragraph, or number 1, Schedule A. Now, as you remember, the old collective bargaining agreement had some language of the Me Too clause, which had to be corrected through a lawsuit and all that. So some of these amendments, and this is one of them, reflects the new language that kind of purges that forever. And this one, so now we're looking at sworn versus unsworn bargaining agreement, bargaining employees. And so this says the county agrees to provide all non-sworn bargaining unit employees with the same or better cost of living increase of other county employees. Because the sworn deputies have to be done by statute. Bless you. So that's all that does. Going down to number 2. Bless you again. Number 2, this is the percentage of the salaries of the sheriff that the different members have. Deputy sheriff, or probationary deputy at 85, because the statute says that the deputies will be between 85 and 90% of the sheriff's salary, and then the undersheriff will be at 95%. So the probationary deputy at 85%, deputy at 86, senior deputy at 87, a detective at 87.5%, and included the 40 hours flex schedule because that detective's going to work kind of whenever. Sergeant at 88. They asked to remove the captain and the undersheriff from the agreement, even though those percentages are correct, because they're not actually members of the bargaining unit. They're managers.
Oh, that's why they're crossed out.
Yeah, so that's what that is. Schedule A, the control clerk, for control, our clerk starting wage at $14.03 an hour. That was, you want to say anything to that? Other than that's just
That's the new starting
it's a new
wage.
starting wage. Same with detention. Article 10 was really kind of an inside baseball deal. This is amendment number 5 on page 2, dealing with how vacations are allocated within among the members of the sheriff's office, and it's just for them. It helps them to manage vacation so that some people don't get all the prime vacation time. And hunting season's a big deal. That goes to number 6 as well, how they deal with vacation. Number 7, Schedule B. What exactly was the change here on this? Was it just changing the actual uniform that each entity is required to have?
Yep.
Do you want to tell us more about that, or is there anything more to tell?
Well, because we've changed the actual dress over there from these type of shirts to the polo shirts since the old bargaining unit came through to, and now we've got eye jackets for court. I mean, there's been a lot of changes actually that we brought forth,
So
and
then,
this covers it,
yeah, just kind of,
a
I guess-
cleanup.
yeah, there you go. Number 8, uniform and equipment. So there are some equipment, there are some things that that I guess the deputies think they need to buy for their duties. And so this gives them an equipment allowance to do that. And then the purchase of it needs to be approved by the sheriff or undersheriff, just so they're not out buying Razoo, I don't know.
Wasn't that 300 before? It's 400 now.
It was, that has never been part of the marketing.
Oh,
That was the clothing,
oh, the clothing law.
so there's clothing and then the
This was other, okay.
sad, I was the lone person to vote against that. Shift differential pay, this is again kind of an issue in terms of dealing within the control and detention, just in terms of incentives for different shifts. There's desirable shifts and undesirable shifts, and so this is just kind of rewarding the people that get the undesirable shifts. Fuel trading officers, excuse me, because it's an additional duty of not just that they're on as a deputy, but they're also training a new person, so that's a little additional compensation there. The detention nurse pay will be equivalent to the other county nurses' pay because she hasn't been up to this point, and it was an equality issue. Number 13, we'll look to that we do it now. Stapled to the very back page of this packet is an MOU that is not binding, but it's a kind of a demonstration of the commissioner's goals to kind of be fair. And what the statute says that if a sheriff's wage is frozen in a year, and obviously the deputies are frozen as well, that when they calculate longevity pay, that year is not included in their longevity pay. So you're both freezing their wage and also kind of taking away a longevity benefit. So what they've asked for is that even in the year when due to financial reasons, the county can't increase compensation for its elected officials, that it would endeavor, try to increase the sheriff's pay by at least 1 cent in order to trigger the fact that even though they wouldn't really get, they'd get a percentage of a cent, what they would get is that year's longevity. So I also voted against this one, but my name's not on the signature line, so it doesn't matter. But what they're going for here is that they get some amount of benefit even a year when they don't get wage increase. So
And it isn't binding.
it's not binding. It's basically the commission will make its best effort to do that. Obviously, if we go into a Great Depression, then that's where you're looking at.
Mhm.
14 was a 3-year term of agreement for the contract. I think what was the previous one, 4 or 5?
No, it's 3.
It was always 3? Okay. Holidays, I'm gonna let the sheriff talk about this one, number 15.
It was just how the holidays fell. Somebody would work the shift before the holiday and get paid, the person who worked the holiday wouldn't get paid over there. So this was just some more house cleaning. And then the hours on the holidays, because they switched from 8 to 10 hour shifts. Now it covers the actual hours they work, the amount of hours, rather than if they were working a 10-hour shift, now they get paid for the 10 hours, rather than as the contractor had before, they only got paid for 8 hours of holiday pay. Does that make sense? So now if they're working a 10-hour shift, they get paid for 10 hours versus what the contractor had was 8 hours.
Mhm.
See, that's the way it was for the deputies before, because it was in the contract. They got
And
paid,
the holiday pay.
they got 10 hours holiday pay. Now, it's uniform across the board for all employees over there, and it doesn't differentiate. It's all fair.
Okay, so then the last one is number 16. And this, basically, they're trying to address an issue where someone gets hired as a new deputy, the county, the sheriff's office buys them all this equipment and uniforms and everything, and then they're just there a short while and they leave. So you've lost the equipment investment plus the training investment, all that stuff. So what they put in here is that if you are a post-certified prior service officer, meaning you've already done a lot of that training and you come in as an experienced officer, there's less additional training and investment that we have to do. But that you need to commit to stay for 2 years. If you're a pre-service new deputy, so you come in and then the county has to pay to send you to the law enforcement academy plus all the other stuff. you need to commit to 3 years of being here. If the deputy wishes to voluntarily leave, then they need to pay back the county for the tuition for the law enforcement academy, plus like the initial clothing cost or equipment that the county buys for them at a prorated rate. And, I think this is pretty fair, and I've seen it with other businesses where they do this, where county's done an investment, so you need to stick around and be committed, and if you leave, then you need to bear some of that cost, so.
Yeah, that 3 years thing, I've heard that before. It never was here though, was it, for sure? It was just kind of a general talk about it, maybe?
So those are essentially what we dealt with. There was one other thing that we wanted from the county end, and we realized we didn't need it in the agreement. So it's not in the amended agreement, but that was just ensuring that if there's a grievance under the union, or if there's a complaint that the way it's handled by the county, that at the unofficial level, that person can deal just with the union rep and the HR, and if it goes to above that unofficial level, then they need to ensure that the county attorney, the sheriff, and the commissioners are made aware of it. Sometimes it's kind of like one right hand wasn't talking to the left on previous, before I got here, issues, and so it's just, if it gets to that point where it's an official grievance and we have to really expend effort to deal with it, that all the representatives of the employer, that term would be defined, are included in that, helping resolve it. So that didn't need to be in the agreement because it's really how the employer, half of it handles it. It was transparent to the bargaining unit member, so it wasn't in the agreement. I've never done a negotiation like this before. I thought it went really well. I thought both sides came with really positive attitudes. That changes, neither side was really asking for a lot. I think everybody felt like pretty good working relationship, and there was just a few tinkering issues here and there. And we enjoyed working with Erin Foley, and give her a hard time once in a while about being a union Democrat, but she dished it back, and she did bring us passes from Butte, so that was good at the end. But I don't know, Sheriff, do you want to add anything to how the process went?
No, I think it went fairly smooth.
You enjoyed it?
Mm-hmm. Yep.
So we probably drug it out longer than we needed to, but it wasn't due to big fights. It was more due to people being gone and things like that. So anyway, I would recommend that the county commission approve it.
I just have two questions. One is the language about, keeping everybody in the loop. That's employee practice, and it should be. Does it need to go into the policies, the new personnel policies, since it's not in the CBA?
Well, maybe. What do you think about that?
I don't want to get into another situation where we're caught afterwards wondering what the heck happened and not having that background, which I think is essential.
And the literally, as far as we got in terms of the recommended language, was that the employer, if it's an informal grievance, the employer is, who is the employer? Is it just the union rep and the HR rep? Pull my, let's see.
That's what happened the last time, and that's why there was a problem.
And it might be because then it went to formal, and then not everybody got brought in at the stage 2. I don't know. That was a couple, the one we're all talking about was a couple of years ago, wasn't it?
Mm-mm. It was maybe a year ago now. Happened last fall, didn't it?
Which one are you talking about?
I'm not gonna state the name on camera. But we had an employee who had an issue. It was worked out, I believe, with you and the union, and nobody else was brought into it. We got a claim saying we had to pay this.
Oh,
And the commission didn't know what it was about.
Me, the union and HR. It was me, Nick, the union and HR.
Michelle has said that she wasn't involved. we can call her, if we want, but I'm not sure that's the
That doesn't-
discussion.
That doesn't matter.
I think the issue is, I wanna just make sure we have something so that we're all on the same page, so it doesn't happen again. And I'm not even sure we need to go back to who the employee was or what the specifics were, as much as we just need to address this so it doesn't happen again.
So Article 12, it just says, kind of like what we just talked about, that there's an informal grievance, or an informal level of grievance, and it's the intent of the union and employer that every reasonable effort will be made to settle it at that level. And it says that they will start first with the immediate supervisor for adjustment. Then if the grievance cannot be settled informally within 7 days, then the union will submit the grievance to the employer in writing. And the employer will provide the union with a written response. So what we had suggested was if we get to paragraph B, so paragraph A was just try to settle it informally with your immediate supervisor. If we get to paragraph B, where we're doing a written grievance and a written response, at that point, the people who need to be involved are the HR, sheriff, county attorney, and then, I guess, how does the commission want to handle that? One rep, or we just do a closed door meeting and advise you that this is what's going on? So,
That would be fine, it's just if there's going to be money expended, we have to be involved. We have to be advised prior, whether that's paragraph A or paragraph B, somewhere we need to have it, I think, in writing, either in the CBA or the policies, that's required.
well,
It wouldn't be a part of the CBA.
yeah, they had asked that it not be in the CBA because it's more of how just the employer handles its half. So I think it maybe should go into the policy.
Okay, could you provide the legal language for Michelle to add it?
I'll make up something.
Okay. Then I'm,
Purely legal, I'm sure.
What's that?
Purely legal, I'm sure.
Here for, therewith, and forever.
so my other question then is the, policy on the market adjustments. Are we going to do that separate? I'm a little leery of signing this without having a clear view of what the Me Too clause, the details are. Not only the market adjustment, but also job descriptions. To what degree do we need to go so that there isn't and there's always an opportunity for agreements. A person can agree just like they can sue at any time. But I just wanna make sure that we're not walking into something that we could have avoided.
Yeah.
So what's your thinking on that?
So we had actually proposed to the union that we would do, one of the attachments would be the county's market adjustment process of doing a market adjustment analysis for wages. They asked that not be included in the CBA, but said, that's a great idea to formalize it and have the county adopt it at some point. They expected that, like anything else on the agenda, they may come and provide comment, public comment. But, and I think it was both that they didn't want to slow down the process as well as what they try to do is make a lot of these agreements similar across various counties. And I got the sense that they didn't say this, I was just kind of trying to read their mind that it was unique enough that they weren't sure they wanted to, just throw it onto this agreement. So I would recommend that the county do that. There's a draft actually that I've seen, I think, from you, and I haven't edited it or responded, so I'm a little slow on that. But I think it makes sense for the county to do that. It might be something that, I don't know if a couple of department heads want to collaborate on recommendations in terms of that document or something, some policy that's different. I'd say the goal would be not make it too complicated, but also don't make it entirely loosey-goosey. That's what I'm saying.
Have you read it through yet? Even
I did.
okay.
Yeah.
Do you think it's to the point where it can just go to department heads for them to go ahead and edit and bloody it?
We could do that. I mean, the
Okay.
general idea is you're looking for, similar duties, similar counties, similar responsibilities. the size of, you know, the number of employees you supervise may or may not be different, or whatever it may be, and then you just go through a process of comparing salaries and economic base and all that, so, I mean, that's the general idea. If there's if there's some people out there that are dedicated, I don't know if, I would say yes.
Okay? Yeah.
Send it and see what they think.
Yeah, and I will open the door with anything that's sent out. Bloody it up. I'd rather get an edited document that's dripping blood than, nobody took a look at it. So, I'll put that out there as well, and if anybody has any questions. Hopefully you guys can help.
That's about it.
Okay. All right.
What do you think?
I think this looks pretty good.
All right, Franklin.
Yeah, you two are the ones that really have to know, Brenda, her department, and you on the legal end, and so that's, taking your folks' advice.
Well, and I just want to be clear, I did throw out the whole, just completely de-unionize them suggestion a couple of times. Just didn't get any traction. I did also say, Teamsters, what trucks are you driving? What are you guys hauling here? I mean, gave her plenty of hard time about that, but it was fun, because I would say if I'm stuck working with the unions, these are pretty good guys to work with. I just don't want all the people on, my family watching on the camera to think that I've suddenly embraced the unions. No, it's fine.
All right, well, we do have decision on the agenda, so we can make a decision today. Franklin, do you have anything to offer?
No, like I say, I think you folks did good on it, and you're in agreement, so,
Let me put it this way, since there's a signature page that includes the commission, I would entertain a motion to approve the CBA on behalf of the commission and the employees of Broadwater County that are under the union.
okay, I'll make the motion to accept the, I'm not gonna repeat the wording exactly, the agreement, I guess, is the simplest way to say it.
I'll second the motion. Did you have a comment, Corey?
I just have a question, so do you wanna, can Commissioner Gravely sign it if she's not here right now? I mean, can give her an opportunity to do that before.
It's a commission decision, so yeah, even though she's not here, if it passes with a majority vote, it's still a commission decision, so she can,
Okay.
yes. All right, any other discussion? All those in favor of the motion, please signify by saying aye.
Yeah.
Aye, motion carries. Do you have an original for us to sign?
I have that. I didn't
Oh,
do
okay.
so that was the next thing, is then
Okay,
Aaron and I will do the full document with all the edits, but I didn't want you guys to sign that one without the approval of, what they did is they voted on that document that you guys just read right here.
okay,
And so then with your approval, so now Aaron and I will get the agreed on master text that has all the correct things, and then we'll get it to both sides for signature.
okay,
Sound good?
that'll work. All right,
But basically, this is it, it's
It's
just
gonna be that incorporated into the full agreement.
Yeah.
Get rid of the old language.
Okay.
all right, so, anything else on that subject? Okay, moving on to 2 o'clock, Corey Swanson, County Attorney, Teamsters Trust Health Insurance Requirements Discussion.
So, I have one for Commissioner Gravely, so I hold that with you. So, what has brought about this discussion was a couple different, one, in the course of the Teamsters discussion, we realized that our work requirements for health insurance were not correct. Ironically, it was based on what they told us to do in January, but either way, it's not correct, so we need to look at change. Secondly, there's been plenty of people in my ear and phone calls to me and whatever over this whole issue of county commissioners having a part-time salary, but then doing the extra hourly work. And as a result of that, I said, you know what, I need to go back and do more research. So this is me telling you that what I told you in January was wrong.
Okay,
And I think I'll do the Teamsters part first on page 2 because it's the easiest. Although it honestly has some repercussions we need to think through. First, they told us originally what they wanted for requirements for eligibility for health insurance was work at least a 32 compensable hours in a week in a month. Compensable is important because if somebody's taken paid leave, that's considered compensable hours for them to be eligible. Now they're saying that's not correct. It needs to be at least 80 compensable hours in a month. They're not doing a bi-week requirement. At least 80 compensable hours in a month. I understand the Affordable Care Act is saying 120 hours in a month for like 30 a week. Is that, we're right?
mm-hmm.
So what that means is the commission can set the hours of worked for eligibility of health insurance between 120 and 80, and you'll comply with both your requirements under the Affordable Care Act and what the Teamsters Trust is saying. They in no way want to go 80 or below, because then we're into health insurance for a lot of these part-time 20-hour-a-week employees. So that leaves us with that number of what we need to deal with. The way the 32-hour thing is currently worded, it could give health insurance compensation to somebody who works just 32 hours, 1 week in a month at no other time in the month. And so that's the issue. So she recommends, Ms. Foley, Erin Foley recommends, that you, whatever change you make, number one, make it retroactive back to January 1st of 2015. Correcting the error that they are responsible for, and I guess we share some responsibility. Secondly, and she was looking at some of the documents and records, and she thinks we have some issues anyway with some of our health insurance trust requirements for the year. So she said if you make it retroactive, it's going to fix a few of the employees here and there that had issues. So now we're into the issue of where would the commission want to set that number for eligibility for health insurance. If you set it at 120, then there's a lot of people that may be currently on health insurance that may be off, including the commissioners. If you set it down at 80, you might have a very wide loop that you've now cast. Where would that number be? So Erin said, well, keep in mind that they could set it at 100 or 104 hours, and then that would be commissioners included. But then all of you would be included. So Commissioner Gray, even though she doesn't want health insurance, would be in the boat that I'm in, which is I don't want health insurance, but I have it because of my work eligibility. So I have 2 health insurances, and that's okay. I pay for them both, and the county pays a very good share of mine. So it's just the way it goes. So that's decision 1, is just where to set that hourly rate. But what Erin is telling me is that our current language is not in compliance with their trust requirements. The second issue, which goes hand in hand with this, is can commissioners have a 26-hour equivalent part-time salary and then authorize additional hours? And after all this research, I'm here to tell you I think the answer is no. And beginning on the bottom of page 3, I went through all these statutes. So Title VII, I brought my book here, so if you want to look at these. So 7-4-2503 is the county compensation board. We all know that's the commission board, or the board that sets the salary for the elected officials. That statute 2503 also says that these county officials need to be equal in their salary, and then there's adjustments. The sheriff gets a $2,000 extra, some of the others get $2,000 extra, okay? But they all need to start at that equal base, and that includes all the county commissioners need to be in the equal amount. Then, going to 7-4-2107, it says each of these commissioners shall receive a salary equal to the salary for the clerk and recorder plus 2,000. But then the commission needs to decide whether to accept that on a full-time or a part-time basis. But it says the board shall accept it that way. In other words, all three are either in full-time or all three are part-time, not, one full-time and two part-time. Now, there are counties who have tried to do that in the past, and there's an old Attorney General's opinion that says you can't do that. But it was also under an old statute that specifically had a sentence in there, which was put in there because of counties doing that, saying, no, you are not going to select one person as the full-time managing commissioner and the other two are part-time, okay? The new statute since 2001 doesn't say that, but it does say they shall each receive this and they shall, as a board, elect to be full-time or part-time. So, what I believe is the correct interpretation of the law is that all three commissioners do basically what happened prior to January, which is you have an equal salary and you're either part-time or you're full-time. Now, there's two different, there's a statute in Title II, General Government, that says the salary of each officer is for all services that are required of the officer or may be assigned to the office by law, including, and it goes on to all these members of boards, do all this stuff. But it doesn't include travel, lodging, or subsistence, because, as you know, there are separate statutes that deal with county commissioner expenses for lodging, travel, and expenses associated that you incur as part of your duties. So those aren't superseded. So then there's an Attorney General's opinion from Attorney General McGrath, who's now the Chief Justice of the Supreme Court from 2005, and it's exactly on point. It was the county attorney from Jefferson County, Matt Johnson, asked, and apparently what was going on, one of their elected officials, I don't know who, was doing political activity, supporting somebody, I don't know, campaigning. Somebody said, well, you can't do that because you're an elected official. And so the question was, can elected officials participate in political activity in their off hours? And McGrath basically said there's no such thing as off hours for an elected official. Elected officials do not have specific hours of employment, nor do they receive vacation leave or other time off duty. They receive annual salaries rather than hourly salaries. Thus they could be considered to be on public time at all times. Then he went on to say, but of course they can do political activity because otherwise, if you become an elected official, you've given up your rights under the First Amendment, and that would be absurd. So you can do political activities, just I can do it. I just can't do it where I'm using my office in this building and my phone in this building and my computer. I have to use my home phone or whatever it is. But pretty obvious, right? Then the Montana Supreme Court adopted the exact same language from McGrath, quoted McGrath, and adopted that language in the case of Molnar against Fox in 2013. So they have adopted the view that as a public official, you're really on duty all the time, but of course, you can engage in all these other things so long as you're not using the public's equipment or facilities. So, what that means is, I believe the correct interpretation of the statute is county commissioners have to have the same salary as each other. It needs to be a salary based on how the compensation board does it, and it needs to be either full-time or part-time, and that's it. They're not additional hourly wages. So, sorry, I'm slow in getting this, and I'm accepting responsibility for the fact that I did give you an opinion that was a rushed opinion, and it turned out to not be correct. So I would say, first of all, sorry, and I'm correcting my mistake. Secondly, the issue of how that affects the issue, and I know there's an argument over Commissioner Obert's use of the time, 32 hours, 40 hours. I'm not even ready to talk about that until doing research, so that's an irrelevant issue to this decision today. Just want to be clear. I'm not here saying whatever. What I'm saying is I would recommend the commission reset that to that, either part-time or full-time. And then secondly, the complicating factor that we were all worried about was health insurance. That's why I presented these together, because the Teamsters are telling us, well, they're not admitting they gave us wrong information, but I'm telling you they did. I was on the phone with their lawyers in Seattle and getting documents from their lawyers in Seattle and emails approving what we did. So they're not going to admit it. I don't care. Based on what they told us in January, that's what we did. Based on now what they're telling us, this is the opportunity for us to not only correct the health insurance requirements, but also relieve a clearly an ongoing problem with the salary of county commissioners. There you go. And I'm sorry it took me this long to get this done.
All right, so, this definitely has to include Elaine.
Yeah.
Before moving forward, on the, subject of the health insurance, kinda off topic, but it's still on topic, with Teamsters, seasonal employees. If we have an employee who is 26, they're under the ACA on their parents' health insurance, they want to work overtime during the summer to make money for college, and a department head is looking at the additional cost for the health insurance benefit if they work over whatever number of hours. Is there anything that it gives us the ability to exclude them from the health insurance if they can prove they have it, since they are a unique situation? I mean, I think most of us who went to college, you know, this summer you try and work 60, 70 hours a week to save up for the college year. This is putting that in jeopardy for some of our college students who work for us in the summer. Anything, any opportunities?
Well, and under the current arrangement, they would probably still run into the same problem. Right.
Right.
So, I don't know the answer to that.
Current arrangement as in January. I was hoping it could be something we could talk to Teamsters about with the new contract.
So for part-time employees that are,
Seasonal,
seasonal employees that are full-time. Or even,
for a temporary,
right.
for a season, yes.
I guess I would recommend that we do bring them in for a more thorough discussion on that. I suspect the answer is they're still gonna be, if they meet that, whatever number we set for eligibility, they meet that for the next month. So, does that make sense?
It makes sense. It makes sense, but I'm worried about what our departments can do and will do based on what they can do, and hindering some of our college students from being able to work
So,
in the county.
So instead of a full-time person, they'll get 2 part-time.
Mhm.
Yeah. Well, that's the problem with government mandates. That's the problem with the effect that we have with minimum wage going up. There are some people that don't hire somebody, or, you know, whatever it may be. So,
It's
in this
not-
case, it's not just a government mandate.
Right.
It is, we as the government are doing a mandate, if we say this many hours. Based on, not just the feds, but based on the agreement we have with Teamsters. I would say that the answer is gonna be if somebody meets that period of, that 80 hours, or if it's 100 hours, or whatever the county's commission says. If you meet that in that month, then the next month you have insurance coverage.
So no chance at negotiations with Teamsters on that one issue?
No, when I talked to them about that, actually, I was talking to their lawyers in Seattle about that, at the time we talked, to ask about a part-time elected official opting out. And she told me, currently, we do not have that as a policy. She said, I can take requests to the board, the board of trustees for the health insurance trust. But, you know, I'm not really optimistic you're gonna get a favorable answer. So, this one, I'm sure we wouldn't be even close to the first group to ask for that. So I could probably email her or Aaron and get you an answer, you know. Obviously, I don't think you'd wanna make a decision on this today, so.
Mm-mm. Not without Elaine.
But I would say that I'd be surprised, I'd be very surprised if they say, oh, sure, we can opt out seasonals, because everybody has seasonals. Everybody does that. I could be wrong, maybe seasonals cost them much more in the big picture, and so they say, yeah, this is a cost savings for us. I don't know. The concern is, what they're concerned about then is any loophole like that potentially harms their unionized members. Okay? By the county doing seasonal workers, we have now avoided hiring an employee who would be full-time who would become part of the union. Not just in us, because for us, we're just dealing with the people in the sheriff's office, but all these other unionized entities,
They're
They
setting a
use-
precedent
they
for
use
other.
that as a way to avoid having more unionized workers. I'm all for it, but
Okay.
that's kind of tongue in cheek.
So my next question is the compensable hours. What Aaron is saying, what you're saying is, we need to set what that number is. We can't say it's between 80 and 120, we have to set it at a number.
We said, yeah, that's correct, set a number. So let's say it's 85 or more, or 120 or more, or 104 or more, that's correct.
Okay.
And then in that, if they work 90 hours and then they're on 15 hours of vacation, they're over that 104 mark.
And this is setting it per month, not per week.
Per month.
Yeah, but vacation doesn't apply to elected officials, like,
Right, so that wouldn't apply to elected officials, that would apply to others.
So this requirement, my question wasn't clear, and I wanna make sure it is, so that we're on the same page. The requirement right now that if somebody has to work 32 hours in 1 week per month is out, right?
Yes.
And it just goes to the compensable hours, whatever we set.
So long as it's above 80 and no less than 120.
Okay. Okay, so does our current practice stand until we have a vote on this, to change it? Or does the current, that has to be, right? So we can put it on the agenda for next week
Mhm.
and take care of all this.
What's the date today? Today's the
Ninth?
9th, so,
16th.
yeah, so there's your trouble, right? If we have let's say we have somebody this week who works 35 hours and then they don't work anymore for the rest of the month. So hopefully we won't have anybody in that boat, but if we do, then we'll have to deal with that on a case-by-case basis. Right now, they consider us out of compliance, and that's why they wanna make this retroactive to January 1st, so then they can make themselves and us in compliance. But in the process, then, yeah, I mean, one more week is gonna be needed either way, just to evaluate it and to get Commissioner Gravely's opinion.
So going retro to January 1st, I don't expect that there would be any additional costs on us, although if we took it to 80, there could be. Are they also asking for us to then make whole any of those back payments if we were to choose 80?
I would say, well, I would say we should do some looking to see how many people would be roped into that,
So that we know?
so that we know. And they think that it will actually, there's a couple deputies in particular, that they think that this will take us out of, right now, we're in a position where they think we should have made whole, made them whole on a couple of different months. That makes sense?
Yes, it does,
So
I know
if-
who you're talking about.
If we go to a higher number, then that takes us out of violation. So that's the only one I'm aware of, so there might be others. But if, say, you go to 104 and you go back to January 1st, so now you have Commissioner Gravely, who was never eligible, now she's eligible, so they may have money just for her for the year,
Okay,
unless we can also get them to waive that.
again, it's not just us they'd be waiving it for, but all that are members, and they've got a precedent issue, right?
Yeah, but in terms of settling possible disputes, they have pretty broad discretion to do that in a way where it isn't considered precedent setting. It's like me, if I settle a case
that's what I would
and
think.
waive some penalty, the next person comes in and says, well, you did that, I say, well, too bad, you're different.
Okay, so that wouldn't be like the seasonals, it would be just this one particular
Right,
case.
this one time to put us back on track, that's what I'm suggesting.
Okay.
You thought I meant like
Mhm.
going forward. We could ask them for that, but they didn't expect that the board would agree to that. But we could ask,
Their board,
yes.
okay, all right.
Now, and like for yourself, now you're not, or you have to take the insurance.
I do.
even as an elected official.
So there had been this unofficial policy that elected officials didn't have to, they could either opt in or opt out. But they were saying, well, there's nothing in writing, we don't know where this came from. I think it was just a matter of a practice that was instituted, and I think that there may have been a period of years when they didn't really audit us thoroughly. I don't know, I'm talking 2011, 12, I don't know what happened, so.
Yeah, well, those weren't elected officials, those were just employees that their spouses had the insurance, they had everything, so they didn't.
Yeah,
That there had been evidently a verbal agreement.
I think, yeah, I think you're right. I
But
think there'd
obviously
been
nothing in writing
a verbal
that
agreement.
anybody can find anyway.
Right, and all those folks are no longer here,
Right.
so that's the other piece of that. Yeah.
So there you have it. So my
Alright.
recommendation is that you do put it on the agenda for decision, and then it's really what range you wanna set, but I think there's really two different decisions. One, to adjust the commissioner salary situation, and then the second, to set the health insurance hours. And that's, it's really just a policy and a cost decision for the commission. And if we really are getting into a point where we're worried about details, then, we can either ask Aaron to come to the meeting, or we could even maybe talk to their lawyers, or either her or them, or have them on the phone for a meeting. So those options are all available.
All right.
So should we have them hear this for the next Monday then?
Well, it's up to you. Is that soon enough for you to look at the issues and talk to Commissioner Gravely next Monday?
Well, we can't talk to her before then, but we can certainly talk to her on Monday, bring her up to speed. 16th.
Okay. Let's do it.
So a question I have for you, Corey, is on the county compensation board. Do we need to convene that board to weigh in on the commissioner's part-time versus full-time? It's just the salary.
Yeah, they're two
Okay,
different
that's what I
decisions.
thought.
So the board is only to set that base salary, which it did. The second decision is whether the commissioners are full-time or part-time. That's your decision.
Okay,
So you can make that whatever.
all right. We will add that to the agenda. And we've already done the CBA, so anything else?
I'm working on hospital stuff the rest of the day, and I am supposed to talk to Julie Flynn about just reviewing their hospital district's loan application. And that's one of my difficult tasks. It has been difficult, but it's, gotta get it done, so that's where we are.
All right. Anything else, Franklin, for the good of the order?
I don't think so. Finish up on Monday then.
So I'm gonna ask one question, because it just relates to the hospital. I had a couple people mention that there's a discussion of dealing with county health going to the hospital. Is that what's
No.
what's the story there?
Is there anything said on that amongst us?
Well, that's what I'm asking.
Yeah.
I had somebody mention to me on Friday, and then someone this morning called me, and I said, I don't know.
Michelle sent an email that Franklin got. He was on the list that kind of opened the door for this whole thing. About 9 months ago, Harold Vladdy sent an email and said, why is your county health under the county and not the hospital? you should look into this, it's an opportunity to save a lot of money and stop duplicating services. So we did. There was a meeting to kind of talk about it on the surface between Linda Campbell, myself, Kyle Hofstad, and Fran Wright, who's the director of nurses.
At the hospital.
At the hospital. Yep. So at the time, Linda was interested, she went back, or at least she was open, she went back to her staff and they said, we're not interested in working under the hospital. She came back and she said, not at this time. Basically, she was going to retire in a couple of months, and that was a pretty big bite to chew for somebody who was on their way out. So it just slipped my mind, and then a couple of emails with Michelle to the three of us, including Elaine, kind of opened the door again. So Kyle and Fran are interested in looking into what the many issues are. One is the grants. Can they continue to get the grants the county gets as a nonprofit? It looks like it, but they want to make sure they do their due diligence on that. Two is, what are the opportunities that are open if we do stop duplicating services and actually put it under one umbrella? If we were a Lewis and Clark County with however many thousand people they have, it makes sense to have different options. We're not. We're a community of 6,000. So that's also got to be looked at. Kyle has organized a trip to Red Lodge. Who has done this? Many counties have, according to Harold. And so he would like to meet with public health employees, the hospital, the county commission, Montana Hospital Association, and us, so that we can start looking into those questions, get some answers, that kind of thing. So what it is right now is a fact-finding time, so that if there is a desire of the hospital to do this, that they have a proposal that's all vetted, that they can bring forward, and then we can make a decision.
Do you know when the meeting is, or the trip?
I sent you an email, December 1st, I think.
Okay.
Almost positive. But yeah, I sent you an email and invited you to come along if you're free.
I have a trial that day, so
Okay.
difficult trial, so that won't be able to go. Okay, so, do you know if the hospital, if they do that, they can do WIC and those other public health things?
That's the grants that they're investigating right now, is to make sure they can. They can do WIC. Can they have it funded through a grant, is the question. There's also a grant with the Board of Crime Control that they could do that I don't know that the county could. And that is a grant for employees of public health, regardless of who they're under, to go to a new mother's home who may not have had the training to take care of a newborn. Things like, how do you deal with a crying baby? How do you change a diaper? Is it proper to leave a child while it's napping while you go off somewhere? Those kinds of basics that some new mothers don't have. We could actually have somebody going into those homes. It's more of a preventive than anything else. So that's something that could possibly be done under the hospital. We just don't have the personnel for it. So it's opportunities like that kind of make it attractive.
Okay.
And again, it's not our proposal, it really is the hospitals. This is their research they're doing.
Right.
I'm trying to stay informed so that if they do bring something forward, it's not a surprise.
Okay, so I don't need to do anything on it right now. It's not tied up in the hospital district stuff.
No, that email
That
was.
was my question. I just want to make sure that I was understanding that context.
I saw you worked on the email from Michelle and wanted you to be informed, just in case somebody came to you with a question. So that was the purpose of that.
Well, I had 2 DUI trials last week, one in both, but when you have 2 trials in a week, not much else, not much else gets answered. It was a rough week, but catch up now. All right, well, thank you for your time.
You're welcome, thank you. And Franklin, last chance, anything for the good of the order? All right, this meeting's adjourned. Thank you very much, everyone.
You
It is 2:28.